Hi there, I'm Ron Wright. I teach here at Wake Forest University at the law school, and we're going to talk about a critical criminal procedure topic when it comes to the accuracy of the system. The question for us today is, how do you get accurate, meaningful identifications? Those times when a witness says, that's the guy, that's the person who committed the crime. Sometimes they're right, sometimes they're wrong. How do we sort out the correct identifications from the incorrect ones? We'll survey the different legal strategies that we have for identification procedures. Let's go in and talk. Okay, folks, let's get started. We're talking about identifications in criminal procedure and the different strategies that we pursue to make sure that those identifications give us good, solid, accurate evidence. Now, we've done a really bad job of this over the years because it's turned out that we're discovering things about wrongful convictions, and when you dig into these wrongful conviction cases, these cases where DNA evidence comes along later and proves that this person that we convicted, it was the wrong person, we got it wrong. And then we do an autopsy essentially of the case and say, what went wrong with this case? How did we get here? And the answer is, all too often, we depended an awful lot on the eyewitness testimony of somebody saying, that's the person who did it, and then it turned out that that testimony was wrong. The person wasn't lying, it wasn't evil, it was, they were giving their very best effort at identifying the person, but they were wrong. So how can we respond to these errors? First of all, you got to know something about the source of the errors. Where does it come from? Psychologists love to study this topic. They love to tell us about how our memory of watching an event is possibly flawed, and those flaws can happen at several different moments along the way. There's the acquisition stage, when we first acquire the memory, and we might get some kind of inaccurate memory right from the start. Perhaps it's too far away, perhaps it's too dark, perhaps I'm completely terrified of a threat. Somebody's pointing a gun at me. There are all kinds of reasons why I might not be at my best as I am acquiring the original memory. And then there's the retention stage. How long do I have to remember this thing before I can tell somebody about it? And generally speaking, this plays out in a curve. That is, I remember a lot within the first hour or two. If I'm recounting this after that initial period, a lot of the details are gone. A lot of my ability to recall the event is wiped out. So the speed of talking to the witness is a big factor in knowing how much detail is there and how accurate, or at least how close to the original memory the later description is. So there's the acquisition stage, the retention stage, and then there's what we call the retrieval stage, the moment when I have to go into my memory and pull it out to give my account of the event. And you can also get some errors at that stage. So it might be that the police are suggesting to me the answer that they want to hear. Or it may just be that it's been too long, or that there is something distracting going on in the room while I'm trying to give my account. There are various ways that at the moment of retrieval, I can introduce new errors into the memory that I'm providing for the investigation. So this is our challenge. We know we're messing up. We know that these eyewitness identifications are very often right, but too often they're wrong. We know something about the various ways that they can go wrong at the acquisition stage and the retention stage and the retrieval stage. What do we do about it? We've got several different strategies, legally speaking. The earliest one was we turned to lawyers. There was a time in 1967 where the U.S. Supreme Court said, in a case called United States versus Wade, I think he was Billy Joe Wade, the court said, we're going to fix this problem of improper identifications by putting a lawyer present there at the police station when the witness is identifying somebody. In this particular case, Wade was being put into something called a lineup. You've seen these in movies where you put people against a wall, they're all lined up together, and then the person says, number 3, it's number 3 who did this. That kind of live lineup happened in Billy Joe Wade's case. But as they were assembling it, the suspect was being showed into the room back behind the one-way mirror, and while the witness was being ushered into the room, the witness spots Wade down the hall being held by the police, and it sort of suggests, that might be the guy. So anyway, it was a poorly constructed lineup. The court says, you should have had a lawyer there because this is such a critical moment in the investigation. He's already been indicted, the charges are present, so the person gets a lawyer, and this is a critical stage in the proceedings. This is really the whole case, make or break. Whatever happens later at the trial is just nothing compared to what happens at this moment when the witness says yes or no, that's the guy. And so you got to have a lawyer there during this critical stage of the criminal proceedings. But that's about as far as it ever went in terms of strategy number one, the lawyer strategy. Because the Sixth Amendment only applies to cases when they're already a criminal case. Most of these investigations happen before the charges are filed, and so you don't get a lawyer once before the charges are filed. You also don't get a lawyer if it's post-indictment, if the charges have already been filed, but the police, instead of having a live lineup, they just show pictures to the witness. Showing pictures, again, the court has said, that's not the kind of thing where a lawyer can really add value. It's not like a conversation, like an interrogation, like under Miranda, an interrogation of the suspect by the police. So this photo lineup, just showing one picture at a time or a whole set of pictures, we're not going to require a lawyer to be present there for that either. So this initial strategy, put a lawyer in the room, didn't turn into very much at all. It only happens for those post-indictment live lineup situations. And if you think about it, well, what's a lawyer going to do? I mean, you can insist that, hey, wait a minute, my guy's the only one wearing a red shirt, everybody else is wearing a white shirt, or my guy's the only person with long brown hair and everybody else has short blonde hair. But apart from that, there's really not that much for the lawyer to do. So court went looking for other strategies. One possible strategy was just to, after the fact, after the actual identification happens, a judge will decide whether it was reliable enough to come into evidence. This happens under the due process sort of general fairness clause of the Constitution. And courts are willing to do this. So they ask two questions. First of all, they ask, was the identification procedure suggestive or unduly suggestive? Like, is the police officer saying, take a really good look at number 3? If somehow the police are conveying to the witness, that's the guy, then you've got an unduly suggestive lineup. One of the famous cases here is called Stovall v. Dino from 1967, where the suspect had been injured during a fight and was handcuffed to a hospital bed. And the witness is brought in and says, see that guy handcuffed to the hospital bed? Is that the guy? And the witness says, yes. So the court ends up saying that's the kind, ultimately they allowed that confession in, but because the police didn't really have alternatives. But that has been the paradigmatic, the classic suggestive procedure. Anything that really points to a particular suspect at the moment of retrieval, the court says that's suggestive. And when that happens, we have to ask whether other factors make the identification reliable enough to overcome the suggestiveness of the process. So the court, in a case called Neal versus Biggers from 1972, gave us 5 different factors that the courts are supposed to think about as they ask whether this is a reliable identification or not. So they ask about the opportunity of the witness to view the crime. Was it dark? Was it light? Was it far away? Was it close? Second, the degree of attention of the witness. Were they really focused on it, or were they just happened to see it out of the corner of their eye? Third, the accuracy of any prior description. That is the person pretty consistent over time in what they described as happening? Fourth, level of certainty of the witness, how sure do they sound? And then fifth, the length of time between the crime and the actual identification. Not all of those factors turn out to be scientifically very valuable. In particular, the certainty of the witness is a lousy factor. People who have, all these psychologists who have studied this over and over again have shown that there really is no correlation at all between certainty and accuracy. And we know this from life. People who are really sure of themselves, and they're wrong about as often as people who are unsure of themselves. So that's not a very scientifically grounded factor. There are a number of state courts that have said when we're reading our state constitution rather than the federal due process clause, we'll change those factors and create something of a higher burden for the government to prove the reliability of their identification processes. So we've got some debate going on in the courts about exactly how to apply these 5 factors and whether to supplement them with other factors that produce greater reliability in the identifications. But at the end of the day, the judges just don't very often knock these things out. Defendants lose a lot more of these motions than they win. Judges are quite reluctant to do this. They're willing to just pass it along to the jury and let the attorneys argue about how reliable the eyewitness testimony was or was not. What's been interesting in recent years, once we've started to get all of this DNA evidence about wrongful convictions and the linkage to improper or inaccurate identifications, what's happened, interestingly, is not so much a change in judicial doctrine or constitutional doctrines. Instead, what has happened is that other institutions have gotten involved. So, for instance, sometimes legislatures are passing laws saying, this is how you have to do a photo lineup. And they specify, all right, the person who administers the lineup should not be the police officer who's investigating the case. It should be double blind so that the officer administering the test doesn't know. Do I hope number 3 is the person or number 4 is the person? I have no idea. I'm not one of the investigators. I'm just here to present the pictures. So the legislation, North Carolina is one example of this, says in a photo lineup, the officer shouldn't ordinarily be somebody involved in the investigation. You should present the pictures sequentially. I'm going to give you 6 pictures. Here's number 1, yes or no. Take it away. Here's number 2, yes or no. Here's number 3. So you just go through and sequentially ask the suspect. You should also assemble photos that are, of course, reasonably similar to one another so that you don't have one photo that, sort of obviously stands out as the suspect. They should all roughly look alike, but you should pick photos based on the witness's description of the perpetrator, not explicitly trying to match or get similar pictures to the one that you think is the suspect. So you match your photos to the witness's description and you hope that you have reasonably similar pictures at the end of that process. So some legislatures have gotten into the act and said, this is really the best practice for these identification procedures, and so you should do it this way, and that'll cut down on the errors. Another important institution that's gotten involved here is state attorneys general, the sort of lead prosecutors, or other sort of management level law enforcement officers have gotten in and said, we need to clean up our own house here. We need to make sure that we're using the proper procedures, the best practices. So they put out manuals, or in some cases rules for investigators to follow that are internal to the department or internal to the justice system. So we have sometimes prosecutors themselves or law enforcement officers themselves saying this is the sort of quality standard that we're aiming for these very important but high risk forms of evidence. And then finally, one last strategy. In addition to let's list what we've got so far. We've got the bring in a lawyer strategy, the Sixth Amendment strategy. We've got the judge watching for fairness, watching for suggestive procedures and whether or not they're overcome by the reliability factors, the due process inquiry. Then third, we've got the legislature getting in and proposing best practices or requiring best practices from law enforcement. Fourth, we've got law enforcement itself creating these rules for best practices. And then finally, we've got the trial itself. At the end of the process, if you've got an identification from out of court, you have to bring that identification in and say, okay, witness, did you see, what happened? Did you see who did it? Yes, I did. Is that person here today? Yes, he is. He's that man sitting there, pointing to the defendant at the defense counsel table. But then the defense counsel gets to stand up and say, let's talk about when you first identified, this person as the perpetrator. How many photos were you shown? And how long had it been since you had seen? And was it dark out that night? And so the defense attorney gets to point out to the jury all the different reasons why you might be worried about the accuracy of this testimony. That's what trials are designed to do. So to some extent, the adversary process still is there to weed out some of the weaker, we hope as many as possible of the weaker inaccurate identifications. Sometimes juries need some help, and so we've got litigation where, in addition to the defense lawyer standing up and cross-examining, sometimes the judge will allow an expert witness to come in and explain to the jury the kinds of identifications that are especially hard. Far away at night, gun pointing at me. There's a phenomenon called gun focus that says if there's a gun pointing at you, you're not that likely to remember other details of who was holding the gun. So expert witnesses can come in and explain this kind of psychological difficulty to the jury in some cases. It's still somewhat rare because it's sort of expensive. Not that many experts available, but it's something that is being litigated lately. Or occasionally, instead of an expert witness, the defense asks for an instruction to the jury from the judge, where the judge says, okay, jury, you're going to think about this case, but remember, be very careful with identification evidence. It can go wrong very easily. Sometimes we have state court cases that say, particularly in a cross-racial context, where a person of one race is trying to identify a person of another race, and that turns out to be somewhat more challenging than intra-race identifications. And so there are some states that now say to their trial judges, if you got a cross-racial identification, you should instruct the jury that they need to be especially careful there and think about the special difficulties of that. So we have all of these strategies going on at once. Obviously, it's still going to be imperfect. We're going to have to be monitoring this over time because we've gotten it wrong so often. We need to be on the lookout for other strategies because ultimately, at the end of the day, what we're after here is truth. What we want is getting the right person. These strategies combined contribute to that. Perhaps not enough, but we're on our way. See you next time.